And if I had to be another person to stand up, if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. All right, everybody. What's going on? We got a late night Let's Talk live session here on the LTL Media channel. Welcome back in. Maybe I've woken everybody up from their slumber. Maybe I've woken some people up from their slumber. Maybe they're getting ready to just hit their head on the pillow and they woke up and they went, wait a minute, LTL is live right now? Yes, I am live. I'm here in the studio. And I just was sitting here. I just did a members only. So I want to welcome all my members in as well. We had a members only about an hour ago. And I'm kind of sitting here and I'm going, I've got to talk about some stuff here. I just had this feeling that we're getting ready to go into the trial. The jury's been seated in the Karen Reed trial, and we're getting ready for 2.0. Opening statements going to be on Tuesday. Tomorrow at 10 a.m., there will be court. That's the last motions hearings. And then again, on Tuesday, it's going to kick off. And I said, I got to go back and take the Wayback Machine, the internet Wayback Machine, and let's go back and look at the hearing that literally blew this wide open. We're going to look at first one Aiden Turtleboy Carney's article on April 18, 2023, the Canton Cover-Up Part 1. That set the groundwork in this. Opened up the doors. It opened up people's eyes. They started looking around and saying, wait a minute here, something's not lining up. And then we knew on May 3rd, 2023, the hearing that blew it wide open. Now, I came in later. I knew about Karen's case. I knew about when it happened, kind of memory banked it, was heavily involved in Idaho content at that point. Then I came in around September. Remember, someone in my chat, in the Idaho chat, said, hey, Karen Reed, you know about that case? It's in and around your area. Ever heard about it? I said, yeah, I remember it. You got to look into this. There's a local guy in and around you that's talking about this, a local reporter. His name's Turtleboy. I go, I know Turtleboy. Started to look into it, and here we are. But let's go back. Let's go way, way back. God, 2023, May 3rd, 2023. I'm going to play through that hearing, but I also found a news article that was crazy that I even could source that from May 3rd. And we're going to look at that really quick and then go and replay this hearing because it's a very significant hearing. It's the one that blew the doors wide open. It's the one that we saw that chalk of Elizabeth Little, that kind of famous photo of her holding that up in front of Bev for probably good 20 minutes or so. And then them going through and talking about Chloe, Brian Albert's dog, how the dog that they believe, and we all believe, bit John in the the timeline of getting rid of that dog, Chloe. So let's do this. I want to see what I just saw. The Goodmans, thank you for gifting 1 membership. So welcome in, new member. I appreciate that. Let me get my ticker tape rolling here. I get the Karen Reed Defense Fund link in the chat. If you'd like to click on that and donate directly to our defense fund tonight, that would be great. But let's pull up this article. God, I couldn't even believe that I found this and I could source it right here from May 3rd, 2023. From Boston.com, the key takeaways from the Karen Reed's latest court appearance in the John O'Keefe murder case. Karen Reed's defense attorneys went head-to-head with the prosecution over evidence in the Boston police officer's John O'Keefe's 2022 death. Defense attorneys for Karen Reed, the woman accused of fatally striking her Boston police officer boyfriend with their car last year, argued Wednesday that the wounds found on John's arm were not from the car's alleged impact, but a dog attack. Prosecutors allege that Reed, following a night of drinking, struck O'Keefe with her car while dropping him off at an after party held at a fellow Boston police officer's home in Canton on January 29th, 2022. She is being charged with second-degree murder, motor vehicle manslaughter, and while driving under the influence and leaving the scene of a collision causing injury or death. During the court hearing Wednesday, the defense team accused prosecutors of withholding evidence in the case. The hearing came just days after Norfolk District Attorney Adam C. Lally filed a memo arguing that Reed's lawyer are on a fishing expedition in pursuit of conspiracy theories that Reed has been framed. Speaking to reporters following the hearing, Alan Jackson, one of Reed's attorneys, doubled down on his client's defense. Quote, "This is now our fight," Jackson said in the video clip from Boston 25 reporter Ted Daniel. "Karen's fight has become all of our fights for some sort of justice." Let's play that.
We didn't stop in there. We're not going to stop on this stair step. We're not going to stop when we reconnoiter tomorrow and in the weeks to come and in the months to come. This is now our fight. Karen's fight has become all of our fight for some sort of justice.
How different everybody looked back then. Look how different everybody looked. Wow. Wild. Moving on, here are a few highlights from Wednesday's hearing. Defense evidence will drive a stake through the prosecution. Reed's defense team requested access to O'Keefe's clothing, evidence taken from Reed's car, and samples from O'Keefe's autopsy, among the other materials. David Yannetti, one of her lawyers, called on the court to set deadlines for the defense attorney to be granted access to the evidence. Oh boy, what we know now, right? Holy shnikes. Quote, with each passing day, my client, who is not only presumed to be innocent, is factually innocent, remains jobless and antiquated health insurance, she said. And with each passing day, her savings and family savings continue to be depleted. There is no time to wait. There is no time to waste. Funny, isn't it? That's exactly what this Commonwealth has been doing to Karen Reed since 2022, depleting her resources, depleting all of her money. She had to sell her house. This is exactly what they've been trying to do. Beat her down and she will submit. But guess what? It ain't gonna happen. It ain't gonna happen. Goes on. Yannetti asserted that every piece of evidence that had surfaced over the past 15 months has been consistent with Reed's innocence and points to Lally as quick to dispute. He added, quote, "However long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution." God, that's such a great quote. Lally said that none of the request evidence is still undergoing. Lally said that some of the requested evidence is still undergoing lab analysis through the results as expected in the incoming days. Isn't it amazing that they are still getting discovery? The defense team still gets discovery in this case. How much fucking evidence have they held back? How much evidence has the Commonwealth held back in this case? We just heard when was the Ted Daniel interview? Maybe a month and a half ago. In part 2, when Karen's inside the SUV, she's like, we're still getting discovery to this day. Fucking almost 3 years later, They're still receiving discovery. Unbelievable. Unbelievable. What caused O'Keefe's arm injuries? Reed's lawyers have argued that O'Keefe's injuries suggest that he has been severely beaten and rather than struck by a car. In court, Jackson held up the autopsy photo of O'Keefe's arm injuries showing wounds he described as a claw and a bite marks from an animal. He noted that at the time of the after party, homeowner Brian Albert owned a German Shepherd that was later rehomed. According to the Boston Globe, a lawyer for Albert wrote in a separate court filing that the dog escaped from a fenced yard for about 4 months after O'Keefe's death and went after a neighbor pet, an incident documented in animal control paperwork. Jeez. I mean, that should tell you something there, right? The family chose to rehome the dog, but remains in touch with the new owner. Albert's lawyer wrote, according to the Globe, request information from the Canton Animal Control and Canton Town Clerk. Jackson suggests that the dog had been present when O'Keefe died. Quote, if there's a fight inside the house with the dog's owner, the dog would likely attack, he argued. However, Lally countered that the medical examiner described O'Keefe's arm injuries as scratches such as made by blunt object and said that the examiner observed no signs of an altercation or a fight. He said O'Keefe was seen leaving the bar earlier that night holding a cocktail glass and told the court that the pieces of the cocktail glass were found embedded in Reed's bumper. Gee, I wonder how that happened. Investigators also noted a shattered taillight on Reed's car and found matching pieces of red plastic in the snow where O'Keefe's body had been, according to the prior court documents. Additionally, swelling around O'Keefe's eyes was not the result of a beating, but due to skull fractures that caused swelling in his brain behind his eyes, Lally inserted on Wednesday. Jackson detailed O'Keefe's injuries pushed back on the medical examiner's findings. Quote, you look like you'd gone 10 rounds with Mike Tyson. As my colleague once analyzed, he said to O'Keefe. Who else said that? Who else said that? Paul O'Keefe said it to his mom when they were all back at John's house. When Karen asked him, what did he look like? Looked like he went 6 rounds with Tyson. Of course, there's evidence that he had been in a fight, he continued. The back of his hands deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anyone who sees this sort of a fight in street fight knows the back of his hands and the back of the arms get the brunt of punches as you cover your face. Of course, there were signs of a fight, not just a fight, but a brutal fight. Pushing back on prosecution's accusation from a fishing expedition, Jackson told the court, I think we've established this as just not fishing. We've got a fish on the hook, but just need the court to help us reel it in. And it goes on to say, what's next? The defense team has filed a motion to examine a cell phone that belongs to a witness in the case. The Reed's attorney did not argue that motion on Wednesday hearing. Her case is due back in court on May 25th. And that was from May 3rd, 2023. And this was the hearing that blew this case wide open. And I want to play it for us right now. What we know now from all of this and what it came to be, right? All right, let's go here. And I will boost the sound. I'm going to just do this. I'm going to boost this up.
All right.
How much? Look how different everybody looks now, almost 3 years later.
Judge 22 HCR 117 Provo versus Karen Reed. Can I have counsel identify themselves for the record side of the
Good afternoon, Your Honor. Attorney David Yannetti and Attorney Ian Henchy from the Yannetti Law Firm.
Good afternoon, Your Honor. Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Okay, so We're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence.
You know, I noticed one thing about this hearing. Notice how packed it is. There is so many people inside that courtroom, that upper courtroom. It is literally packed. People are standing. That's how packed it is. The good old days when we could all get in there, and you can see the perfect shot of Aiden during this entire hearing as well, too.
Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life, and for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from two coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11 months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited.
Still, look at this, arguing to get discovery. Even back then, arguing to get discovery. I mean, it's been like the common theme through this whole trial, through all these hearings, arguing to get discovery.
From inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it. We haven't inspected it. We haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted with Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was, that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day,
you believe almost 3 years. 3 years. We don't know how long this is going to drag into the future. 3 years, we're almost here.
Client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started.
Unreal.
Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap.
My math is not mathing. I was just thinking about it. It's not 3 years. This is almost 2 years. My math was not mathing. I mean, that's like coming up in where are we at? We're on April 15th. I mean, 2.5 weeks. 2.5 weeks, 2 years ago, you're sitting in this courtroom.
In that video from 12:37 a.m. to 12.
My math is not mathing here. I keep saying 3. I don't know why I'm stuck on 3. 3. Like
39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file. I'm sorry, the Canton Library provided this evidence to them via a share file link with a guest ID and a guest password.
Oh, scary.
We need that link, that user ID, and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor, to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15...
almost 3 years since the case started. 2 years since this hearing is what I was trying to say. I'm like, my math is not mathing here. But that's what I meant. That's what I meant.
15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold while she spends every waking moment defending herself emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided.
Look how much hair he had back then. How much hair he had back then.
Thus far is inconsistent with the defendant's guilt and consistent with her innocence. I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th, that those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as
Lally talking in circles here.
Yesterday that timeline is still a viable one. The case is currently in technical review. So once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the Attorney's Office of State Police's custody. One of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA, for comparative purposes to Mr. O'Keefe, would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails. I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether.
Squeaking noise is the Zoom call, so someone probably wasn't muted. Isn't this where someone's like, "Free Billy Tibbetts"? And they scream it in this this hearing? I think when Alan Jackson gets ready to talk or something like that.
Not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still.
And listen to this. I mean, we're back 2 years ago, and the Commonwealth is still making excuses about discovery. Still making excuses about getting discovery over in a timely manner.
Contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was.
Remember the CD, the ID, the Canton ID expert or whatever, and he gave the CD. He's like, "That's not the CD that I gave." Remember that in trial 1? That's not the CD I gave them. That's. Oh man.
Trooper Don, who received that video, not Trooper Proctor. If I could just speak briefly as it pertains to Trooper Proctor, there is no conflict. Trooper proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to the Rule 17. So there's been some photograph taken from a social media site, which is purported to be Trooper Proctor with one of the McCabe's children who are a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have is a video, what exists as a video. What we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay.
Well, isn't that ironic? Isn't that ironic? The link expires, then you have no access to it, so you can't get it. And then, oh, it had to be downloaded and archived and then put on a Citrix file and then transferred over to the defense. Interesting, huh? And he goes, that's the video that we received. Oh, really? So it was like received when you had that missing couple of minutes of when Karen Reed drove by the library?
All right, your next motion?
Interesting how that works.
Okay.
Party on, Wayne. Party on, Garth. Wayne's World. Wayne's World. Party time. Excellent. Here we go.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue. That Rule 17 motion, we're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are essential to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number 1, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found,
here it is.
He had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal.
So the clicking that you're hearing, if anybody doesn't know, that's the photographers inside. It's probably the mainstream media press, but that's the photographers taking photos. It's like rapid shutter. That's what you're hearing. You hear it a lot, like presidential, when the president gets up in speech, speaks, you'll hear a lot of that. Any news conferences, stuff like that. The press is there. That's what you're hearing. The clickering shutter of the shutter, opening quick, shutting quick. It's kind of rapid fire, they call it.
the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question.
Yeah.
Does this look like a road rash?
Right.
I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body if someone is rolled under a car?
Elbows.
Because in gravel, because of the car. What about the shoulders? What about the knees? What about the ankles?
Elbows.
What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the...
Every night I feel like I just have to address this. It's my show. I will do what I want. I will stop it when I want. This is very easy, accessible to find that video. You can search it on YouTube. Have a good night. This is what we do here. We have an interactive chat. We stop, we talk, we laugh, we make noises. That's the way it works. If it doesn't work for you, this is probably not going to be the channel for you. I can't sit here all night and do this. That's not the point of a live show. So, see you later. Have a good night. I'm getting tired of having to do this every single night. People have been lately coming in here and telling me how to run my show. It's my fucking show. I'm going to run it any way I want to run it. That's why people come here, because they enjoy the way that I run it. They enjoy the content that we put out. They enjoy the discussions that happen on this channel. I'm getting really tired of this lately. Don't fucking tell me what to do here on this platform. This is my platform. These are my friends hanging out in the chat. If you don't like it, go watch a fucking mute channel where they sit there and don't do anything. And you want to be bored to death. If you haven't seen the hearing, it's very accessible on YouTube. Holy smokes, I'm getting fucking tired of this.
Commonwealth's own expert. She has to have opined about this.
You're
correct? She has to have said.
You're interrupting me. You're interrupting me, and you're interrupting my friends hanging out here in the chat. All right.
During the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer.
You've never watched a live show before? You don't think that people stop and talk about things and pause it? You got to be out of your mind. That's what this is for. It's an interactive show. It's what live streaming is. Holy shmikeys.
What does the Commonwealth's own expert say?
Oh, fuck.
First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California,
with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop.
Full stop.
So, what do we know about animals?
Here we go. The timeline.
And the Alberts?
I love
Which is
the
exactly
chalk.
where.
I love the chalks. I love the fact that they put the motion in to bring them back. I believe they're going to be allowed to do it. That screen, and I sat in there and I sat in court that day. The screen that they have up is super difficult to see. It's so far back from the jurors. The glare on the screen sucks. I think bringing the chalks back makes it a lot clearer. It's old school lawyering. And, you can bring them right up to the jury if they need to see them. And it's very presentable. And it just, for me, it just works better. And I can't wait to see what they're going to bring in.
Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death?
Yeah.
Because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions.
I believe they will.
The answer exculpates.
There's still a lot of meat on the bone. Like Todd McGee says, a lot of meat on the bone with a lot of this stuff. And I can't wait to get into it tomorrow night at 8 p.m. with brother counsel and my good friend, retired Mass State Police, Todd McGee. We're going to really get into that evidence again and talk about it.
Hates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because
Erica Madden checking in $20 says, I literally can't believe the meet and greet we held was in September of 2023. It's so long ago. I mean, all of our lives have changed so much. I mean, if you follow this, all of our lives have changed so much. And Erica is a fantastic supporter of Karen Reed. Has done a phenomenal job opening up her restaurant to help Karen raise funds, have all these fundraisers. It's amazing. Star Drive-In's just amazing. Has done some really amazing things and great events for Karen. They've been a lot of fun over there. I thoroughly enjoy my time over at the Star. And thank you so much for the 20. I appreciate that. All right, let's keep rolling through.
multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a grand jury, a federal grand jury, to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll.
Oh, wow. I heard about the feds. Look at that.
I would implore the court, now is the time for the court to take some action and give us.
I want to go back there and listen to that again really quick. Let's go back. Ah, you son of a gun. Let's go back. I just want to hear about the feds again.
The circumstances surrounding this case and have impaneled a grand jury, a federal grand jury, to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll.
Look at that. Feds. Wow. We're hearing about it.
I would implore the court, now is the time for the court to take some action and give us the tools, the defense, the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is,
how different Karen looks now,
is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something, and then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, those summonses issue, our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated, and we've suggested, that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to
And they're still getting discovery as of today. It's crazy. Still getting discovery in this case, almost 3 years later.
do because of that, let's let Mr. Lally respond to your remarks on the question first.
Thank you.
Fucking Lally.
Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's facts section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand.
You know what's a lie about this? How they keep saying that the cocktail glass was embedded in the bumper. He keeps saying that. It wasn't. It wasn't embedded in the bumper. And it didn't even match the cocktail glass.
The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
And it was never embedded either. It was never embedded. And how the hell would that piece of glass stay on the back of that bumper all the way from Karen's house in Dighton, all the way back to the Canton PD in a fucking blizzard, and then be unloaded and offloaded on a trailer? But that glass is there, and then the glass doesn't even match the cocktail glass. So where the fuck did the piece of glass come from? The glass sprinkle theory.
As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as "it could shed light," or "if true, this fact would undermine the prosecution's entire theory of the case." There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record, those are not the calm series. No one ever said that the vehicle struck Mr. O'Keefe in the head, and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But
real quick, Historic Hank, way up there in Canada. Thank you so much, my friend. A $10 super chat says, thanks for taking us back in time. No pun intended, right? I need my, let me see, right here. Right? No pun intended.
those could, and if true,
Thank you
those
so much.
very words by definition evince the very nature of this particular request. The first issue would be with the time frame, as it's stated within the motion. It's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head. That there's evidence of defensive wounds. There's a cluster of deep scratches and puncture wounds to his upper arm and forearm. And then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, when Mr. O'Keefe was taken immediately from the scene where he was, his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
That's not me. That's the court feed. It'll come back. Come on, little doggy.
That apparently this doctor looked at and saw things that no one else saw, as far as how the medical professionals detail what those injuries are. In those medical records, what the personnel at Good Samaritan, the doctors, the nurses who examined Mr. O'Keefe when he came into their facility, they describe his injuries as a right superior orbital ridge region, approximately 7 millimeter laceration. Positive for surrounding soft tissue, swelling, and positive breath sounds bilaterally, pulseless, positive superficial abrasions to the right forearm. Dr. Scortibello, the medical examiner in this case, who testified at length before the grand jury, described Mr. O'Keefe's right arm injuries as scratches caused by a blunt object. She described or noted that they appeared to be in a linear pattern. She detailed that she observed no signs of an altercation or fight from her.
Never any stupid questions for the newbies. Sorry if this is a stupid question. I'm new to the channel, but not this case. I'm confused about this hearing. Is this current? Where is Hank? So this is an older hearing. It's one of the first, it is the first streamed hearing, I believe, that was streamed at the time. And you have to think, April 18th, Turtle Boy article comes out, Canton cover-up, Part 1. That article starts awakening everybody's eyes to the situation. And then we have the May 3rd, 2023 hearing, and that's what we're watching right now. So I'm kind of taking us back in time, and that's the title of the video. The Karen Reed hearing, 5/3/23, that blew the doors wide open. This really opened everybody's eyes to what was going on. This is the one that got kind of the water cooler talk happening. And then there's just so many others. I think they were back in on the 23rd or the 25th of May. There was multiple hearings. So that's why, we're doing this. We're just going back in time and talking about the hearing that kind of blew this all wide open. Yeah, and 418 was a wild day. Absolutely wild day. So no, never a dumb question. We like to square it up for the noobs. And it was a great question. And the reason Hank is not there is because he wasn't on the case yet. He's not part of the prosecution team. So it was just Adam Lally at that time. And he was the one. All right, let's continue. You got about another 25
Thorough
minutes.
internal and external examination
Thank
of
you for
Mr.
joining
O'Keefe. And lastly, she testified in great detail as to the swelling of his eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That
Melinda, thank you so much for the $10 on Venmo. It says keep shining and showing up. Do it. Thank you, thank you, thank you.
then caused a swelling on the brain, which she observed as well as Dr. Stonebridge observed
was
during
2
her
years ago.
neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There's no evidence that.
Let's see here. Maybe you can answer my stupid question. What happens if anyone mentions the feds in the second trial? I believe it's going to open the door. Didn't we kind of hear that in the first trial? We had a little slippage on the stand. Not until the feds. I talked to the feds. Remember Nagel? Not until I talked to the feds. It opens the door. Remember, it's a new trial. It's a new trial. They haven't even ruled on the ARCA motion yet, right? The voir dire. Has Bev ruled on that yet?
Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction.
Yeah, tomorrow they are. Yeah, that's right. I did read that in the article that I read earlier this evening. That tomorrow at 10 a.m., they're going to rule on all the unaddressed motions. That's going to be really interesting tomorrow. The good thing is I'm home tomorrow, so I'll be able to watch it. Maybe I'll stream it from my house tomorrow. And I'll just pull the screen up and run it probably. Just pull comments up as we watch it because I don't have anything to do. My car's going to be in for service, so I'm going to be pretty much home all day. All right, let's go.
The operator of the vehicle that Mr. Nagel is in then essentially flashes his lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls on. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house, and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death. and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right. What's it for? The evidentiary hearing?
Yes.
So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That makes sense to me. That makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally. I'm not going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you.
Come on. She needs her time too. We're not going to hear any of that. I don't want to hear a preview. Come on. I need my weekends too, right? What day did that fall on? I got to look here. Hang on. If it's fucking Friday, I'm going to laugh. What day did 5/3/23 fall on? It was a Wednesday. It's me. She's getting ready for She's getting ready for Thirsty Thursday. 4 o'clock cocktails, right? I like how she's just like, we're done here. I like how she just cuts the hearing. We're done here. I need my weekends too, Mr. Jackson. All right.
With regard to the dog,
I can't take it. We're done here.
First of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack.
You guys are the best.
That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten, facially, and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of him. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, and we don't suggest that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce
I don't need to see that.
these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car?
I like Aiden's face here.
Broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm. Then John stood there while she jumps in the car, slams it into reverse, then hits him with the car, with her tail light in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went into the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, you would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger
Very
compartment of her
important.
car, and that she sat there alone.
10 and 2.
And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, there's no sign of an altercation or fight. How can he turn around and say that a cocktail glass did this? They can't talk out of both sides of their mouth. How could they reasonably ignore 2 black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, or what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show,
No, the court officers were there because I think there were union representatives of the Boston police there. Like all those guys in the back, all the bald head guys, those are all Boston police union reps. And because there's so many people in the standing room. So probably my assumption in a lot of that is to protect all that. All right.
I already have the records. I wouldn't need the court to ask for them. Of course, I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog. Which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all 4 standards of Lampron, and the summonses should issue. And also,
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to...
Hurry up. It's 4 o'clock.
Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to a cocktail blast would be somewhat ridiculous. That's not what I said. And that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel,
let's get this. Dirty Bev says, please refresh subscriber amount, hoping you hit 40,000. I'm very close. At the moment, let's take a look. I'm at 39,709. 39,709. So we need 291 to hit the 40,000 club. That's cool. It's a lot of hard work. I've been grinding my ass off here on fucking YouTube for almost 5 years. Yeah, about 5 years. Grinding it out. Pretty cool. Well, we'll celebrate at 40,000, right? All right, let's go.
what is in his testimony is that he had the vehicle. They arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data for Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, Commonwealth would submit the defendant's not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court specifically.
I'm going to get to this really quick. Anthony from Ohio, longtime subscriber here on the channel. Thank you so much. Said, didn't Ryan Nagel say that he did not see John inside Karen's SUV? That means John went inside the house. That is true. Said when he drove by, I saw a woman inside the vehicle, 10 and 2 on the steering wheel, dome light on. I did not see anybody else inside the vehicle with her. He did say that.
Specifically, the Commonwealth's motions to impound and the Commonwealth's motion for access to the
10 and
defendant's
2.
Okay, I'll hear you.
So there were two motions to impound that the Commonwealth filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits
Oh, look at it.
to the opposition to this specific motion, and really to
Okay,
both motions.
and those are impounded by statute.
Right.
Well, thank you for joining
The
us.
other motion to impound that I had filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure I'm not sure they hear you.
In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe. I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point.
Funny, it's they protect the niece in this document, but they sure as hell get those kids up there and put them up and have to go through this horrible trial, sham of a trial, horrible experience. They use those kids in trial 1, and they're going to put them back up there in trial 2. Can you imagine the trauma that those kids have through all of this? And they're still very young and having to go through this in a very young age. They're going to literally need counseling probably for the rest of their lives because of everything they have been through. It's disgusting to put those kids up there and go, did Karen and John fight? Yeah. I mean, doesn't every couple? Don't every couple argue and have an argument here and there? To use those kids, it's absolute disgusting of the Commonwealth. And the O'Keefes to allow them to even go up there. It's disgusting. It's unwarranted. It's unneeded.
At this point, given the public release of them being impounded.
Mr. Unetti?
Yeah, exactly. It's a said kid.
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is, the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just filed on behalf of his motion.
Right, and we don't have.
When he was taking issue with the defendant who filed.
Okay. Yeah, again, we don't have an objection at this moment.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed.
You want the one out of there.
So-
The hearing over?
Is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant.
Sarah Griffith checking in. Thanks. She's coming in a bit late. And I just wanted to say I love your commentary and discussions. That's the added layer to your show, and it makes it meaningful and so important. Thank you for all that you do. Well, thank you for checking in. Thank you for checking in those kind words. You know, listen, this is what we do. It's a live show. You know, I mean, what do you want me to do? Just sit here and not do anything, not talk about, not engage the audience and ask them how you're feeling or, you know, want to know the things that you're talking about? That's the purpose of a live show. It's a live interaction. And I always just get upset when people come in and they go, don't talk over the video. It's like, I'm going to talk over the video. It's what we do here. And it's for fair use as well, too. You got to stop and talk. So, I mean, it's like what we do. I mean, you've never watched a live show? Jeez. All right, let's get another 4 minutes in here. We're going to wrap this one up. It is getting late.
And phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still have received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Thank you.
Clerk? Motion's allowed by agreement.
Just one other thing. Mr. Lally had mentioned to me, and I don't know if he still intends to be heard on this, but there was an issue of exhaustive testing that I thought.
He argued that a while ago.
Okay, and was that acted upon by the court?
He said he was waiting to hear back from you where we stood on that.
Right, so with regard to that, Judge, we're all for exhaustive testing as long as we can have our expert present at the time.
So, Mr. Lally, would you explain to would you say again what you explained to me?
Certainly, Your Honor. So there's a form that's provided by the lab that I then provide to counsel. In this case, in any case, that where exhaustive testing is necessary and the sample would be subsumed within the analysis. So I provided that to counsel. I just simply need counsel to execute that form, indicate whether or not they want someone present and who that person is, what their contact information is, and then I'll provide it to the lab. The lab will then contact their expert and schedule a time for the testing to be done.
Okay, we're happy to do that, but my understanding from Mr. Lowry's earlier argument is that only applies to the hair that was found on the car. That was not part of any motion that we had today in terms of a motion to compel. What about the other evidence with regard to the tissue samples and everything else that we actually asked for in our motions today?
Is there exhaustive testing on any of those items, Mr.
Not that
Lally?
I'm aware of.
Okay, fine. Yeah, so we'll sign regarding the here. We're not concerned about it.
Okay, is that everything?
From the Commonwealth, yes.
I believe so, Judge. Thank you.
All right, thank you. We'll see you on the 25th.
Jesus.
5:25 at 9:30, correct?
Like, geez.
9:30, thank you.
That's it. So again, I just wanted to take everybody. Gonna go back in time, right? Dun, 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 dun. Gonna go back in time. Back to the future. And that's it. So I just wanted to run through that. The hearing that basically blew this case wide open. And tomorrow we'll clear up all the motion hearings, and then trial is set to start on Tuesday. We are not at 40K. We got a long way to go. We're at 39,718. So we got a while. We got a little while to go. I don't know, everybody. I think that's going to be it. Just wanted to dip in really quick and do a quick live stream with all of you and take you back to memory lane. It's been coming up on 2 years as of that hearing and almost 3 years in the Karen Reed saga. Unbelievable. 3 years. It's crazy. Crazy to think we are there. I don't know. I think tomorrow I might stream from my house the motion hearings. Yeah, maybe I'll do that. So if you all want to come over and join me, I know every law tuber and their grandmother are going to be streaming tomorrow. But if you want to come hang out with me and about 10 people in the chat, it's perfectly fine. I probably won't be on camera, but if I don't really like to stop and talk over the hearings and stuff. I usually just play them straight through and just pull up chats. So if you happen to come hang out with me, if I'm going to do it, please do. Love to see you all over there. And it's nice to see everybody here. Please make sure to like, share, and subscribe. Tomorrow night, 8 p.m. Eastern Standard Time. Don't run away yet. You need to set your reminders. I'm going to have retired Mass State Police Todd McGee on with Martin Radner from Brother Counsel. I'm going to drop that link there. Click on that. Set your reminders. 8 p.m. Eastern Standard Time tomorrow, just before Turtle Boy, and assume he's going to probably be at 9 o'clock tomorrow. So just before Turtle Boy, you can come out, hang out with me for an hour. And then when Aiden starts, you guys can head over there. All right, everybody. Thank you. Thank you so much. I'm going to head out, hit the outro. Everybody have a great night. Peace.